Hello and welcome back. My name is Glenn Smith, elder law attorney with Lifescape Law and Development. Again, from my perspective, you are absolutely brilliant because you're taking charge of your personal development in an area that adds tremendous value to your practice. You are equipping yourself to help your clients in their aging process. This series is about elevating you to hero status within the lives of your clients and their families. In session 1, we looked at the elder care continuum. Now you understand the basics of the 4 factors in effectively planning through the continuum of support. In this session, we're going to examine the basics of elder care and asset protection planning. From our experience, we've discovered that seniors share a few secret fears. First, fear of devastating events taking away their assets, freedom, independence, lifestyle, and control. Second, fear of being alone, isolated, and neglected. And third, fear that there are questions they should be asking, but they have no idea what those questions are or where they might find the answers. One of the greatest services and value that you can provide to your aging clients is to show your clients empathy, acknowledge their fears, openly legitimize them, and then address them directly. First, assure them that hope and resources are available to address their financial, legal, and personal care needs, which allows them to make the journey with confidence and optimism. Second, give them some valuable insights into elder care and asset protection planning. Elder care and asset protection planning is for older adults looking to get a head start on protecting their family assets and laying the groundwork for their care and financial legacy. These folks are proactive. They're looking to get a plan A with backup plans and contingencies. These folks are determined to remain in control, to determine their care on their terms and how their lives will turn out. Who benefits from elder care and asset protection planning? Well, it's folks concerned about the escalating cost of future long-term care. Folks who want to steer clear of becoming a burden on their children or relatives. Remember, the latest figures show that the average cost of care is $7,441 per month per person. Another group who benefits from elder care and asset protection planning are folks who are healthy, still living at home without assistance, and want to get a plan in place that allows them to age in place in the comfort and familiar surroundings of their home. This includes folks recently diagnosed with a chronic illness, but are still able to manage their self-care activities and life. Let me share another true story to illustrate this point. In October of 2020, George came in for a consultation with us about his wife, Patricia, who was diagnosed with early onset dementia in 2015. Patricia is now incapacitated. George can no longer take care of Patricia, and George is looking for help. Unfortunately, due to their failure to plan earlier and some defects in their estate planning documents, their options are minimal, which included depleting over half of their assets for Patricia's care, forcing Patricia's care to be in a skilled nursing facility rather than at home, and it made for a real difficult consultation for all of us. One of the huge problems that we see too frequently is this. Patricia's financial durable power of attorney did not contain what we call enhanced powers. Powers that would allow her agent, husband, to gift her portion of their assets to her husband or other family members. The durable power of attorney did not allow for the creation of trusts or the change of beneficiaries, all of which are basic asset protection tools. And since Patricia lacked capacity, we could not fix the problems in their durable power of attorney. Once again, if you don't do what you need to do when you need to do it, somebody else will do it for you. In this case, for George and Patricia, the government made the decisions for them, and their family didn't like it. I'll circle back to George and Patricia in just a few moments, but here's the truth. Those that plan early and work their plans have more options, get better care and results, and maximize their assets. A customized elder care and asset protection plan includes aspects of elder law, estate planning, as well as asset protection. That's where our team wears bifocals. We're looking at both their short-term needs as well as looking ahead. We're analyzing, we're projecting what tools, resources, and strategies need to be in place, implemented, or acquired to best meet the anticipated needs of the clients in the future. Some of the most common tools, resources, and strategies utilized are put in place a financial and health durable powers of attorney. Practically speaking, properly drafted powers of attorney are the bedrock of elder care and life care planning. Now note, if your client has powers of attorney, have them reviewed by a qualified elder law attorney. If the client has properly drafted financial powers of attorney, then that client has numerous options and strategies available. On the other hand, if your client fails to have a durable power of attorney or fails to have a properly drafted durable power of attorney with enhanced powers, then that makes for a very sad conversation about the consequences and options that are available. Second, we conduct a home assessment and determine what remodeling needs to be done for the clients to age in place. Generally, to age in place, home modifications are required to make things more accessible, such as a chair height toilets, ramps, walk-in showers, handrails, and a washer-dryer unit on the main floor. Then we help clients coordinate the decision-making process of finding and selecting the contractor and monitoring the completion of the work. An elder care and asset protection plan also puts in place an estate plan for the disposal of assets, which minimizes uncertainties and maximizes value. We help clients prepare for the transition of wealth after death, minimize the impact of estate taxes, and protect their assets from their creditors and/or the creditors of their children. We ensure that the family property that goes to their heirs is protected in the event their heirs get a divorce. Fourth, we implement asset protection strategies. Remember, every plan is customized to the client's goals, lifestyle, and concerns. For example, plans may include the transfer of assets into an irrevocable trust. We just call them asset protection trusts to help the clients understand their primary purpose. The plan may include periodic outright gifting, use of limited liability companies, or family limited partnerships. The plan may include retitling of assets, or converting countable assets for public benefits to non-countable assets or into a stream of income. Now, from our experience, those asset protection trusts are an essential part of the long-term care plan for the middle class. If properly drafted, an asset protection trust protects the assets from creditors, including the government, because the asset protection trust makes those assets unavailable to the government, unavailable to the creditors of your heirs, including the disgruntled spouses. And that also makes them uncountable for public benefits such as Medicaid and VA. And yet there are means by which those assets and income generated by the assets in that asset protection trust can be made available to your clients for their care and for their other needs. Check out the handbook that we've provided you in this session. That handbook goes into further depth on asset protection trust. Now, let's bring it full circle. Remember George and Patricia? The team at Lifescape Law and Development work with people like George and Patricia every day. George and Patricia made the choice to wait, procrastinate, and just to see what happened. We see it all the time. Our team encourages people to face their challenges head on, investigate the options, get a plan, and then work that plan and move forward in confidence and optimism. If George and Patricia would have consulted with us in 2015 at the time of Patricia's diagnosis of dementia, rather than 5 years later, that couple most likely would have transferred their home and some of their assets into an asset protection trust. Most likely, they would have retained most, if not all, 100% of all of their hard-earned assets. Patricia's care would have been paid for by the government benefits, and she would have remained at home with George a lot longer. Most of you probably have clients just like we do that look at us and say something like this: Glenn, I want to control my property and my life while I'm alive and able. take care of myself and my loved ones if I become disabled, and give what I have to whom I want, the way I want, and when I want, while saving every tax dollar, professional fee, and court cost possible. And the good news is, most often, if those folks take action, plan ahead for their future needs, they'll get what they want: control, care, support, protection, and peace of mind. Remember, elder care and asset protection is for those looking to get ahead, to make a plan, and be in control. Next session, we're going to be looking at life care planning, a new development in elder law. Folks, you're doing a great job. 2 sessions down and 2 more to go. All of us at Lifescape Law and Development look forward to our time together and sharing how to elevate yourself to hero status in the lives of your clients and their families. Until then, onward and upward.